Assalamu alaikum. And thank you very much that I have the possibility to give another presentation on constitutional issues before you. It's a great honor to me. I specifically appreciate your openness for discussion. As it was said, we didn't come here to preach to you. We just would like to explain our experiences with all positive sides and also all shortcomings. We are also critical with our own constitution from time to time. It is necessary. Talking about fundamental rights, they are in the center of German politics, we may say. And if you read our constitution, it starts with the fundamental rights. The first article says protects human dignity as a new constitution, but the very first article, human dignity, it's untouchable. And this is very telling for the sense and meaning of our political system. The list of our fundamental rights is pretty short. Only 19 articles. We do not have social rights. This is criticized by many people. The idea was that the implementation of social rights is much more difficult than the implementation of the liberties and freedoms. Why? Because as a rule, social rights require money, and money is always short in demand. So this is a problem, therefore a certain reluctance in the German system with regard to social rights. Nevertheless, this is very interesting, our constitutional court construed also liberties, for example, dignity and the freedom or the right to free development of their own personality as a basis for social demands. So in this sense, every person in Germany has a right to the minimum guarantee of income or of subsidies, social benefits. And this is, for example, also true with regard to our asylum seekers coming, some of them from Iraq. They are entitled by our constitution to a minimum social benefit so that they can survive. This is so, although we don't have social rights, it is derived from the social rights via the interpretation by our constitutional court. Perhaps I can say one of the most important provisions in the constitution is the Article 1.3 or paragraph 3. These fundamental rights are binding upon all state power. This is a very important point, because it means not only the legislator, not only the government, also the judiciary are directly bound by the Constitution. And the Constitution is a directly applicable document. This is interesting. I don't know if you are familiar with the history in France. They were the first having this famous Declaration of Human Rights. But it became applicable only in the 70s of the last century. This was only sort of preamble. This is a very interesting development. In Germany, it's written in our constitution, they are directly applicable. So there is a daily practice of the application of fundamental rights. Whenever I offend you, let's assume the case, and then there is the question, of course, of your dignity, and on the other hand, perhaps my freedom of expression. You know, and when the criminal judge has to deal with this question, he has to take into consideration, on one hand, your dignity, on the other hand, my freedom of expression. So applying criminal law, this is very important. When the legislator adopts a law, there's always a check if this law will be in line with the Constitution, specifically with the fundamental rights. So they are binding. This is, here I insist on it. Fundamental rights, freedom, but there is no freedom without restriction, and you already mentioned it several times in your discussion today. Of course, there must be the possibility to limit it, because my freedom of expression does not allow me to offend you. So there must be a sort of restriction of the fundamental rights. And as a rule, there are different techniques. One is that each fundamental right has its own form of a restriction, or there is a general clause. The German constitution chose the first approach. So almost every fundamental rights has its own restriction clause. The European Union, for example, in the famous Charter on Human Rights of the European Union, there is a general clause for the restriction. So this is up to you. It's depending on the constitutional legislator which form he prefers. Restrictions does not mean these rights can be restricted. There are restrictions of the restrictions by form and by substance. By form, a constitutional right, fundamental right, can be restricted only by law, because constitutional rights are the rights of the citizens. And it is assumed that the legislator is a representative of the citizens, so he speaks for the citizens. Therefore, only the parliament has the right to establish restrictions, which then might be implemented by the government, by the administration, by the judiciary. But it is without a law, ordinary law, it's not possible to restrict the fundamental rights. And we had problems to this end in times of the pandemic in Germany, because we were not very well prepared for such a situation from the viewpoint of legislation. So if you want to hear more about it, I'm more than willing to explain it. Restriction, and then there is this famous principle of proportionality. This is as for substance. First of all, as a rule, it's always better to have a certain enumeration for the scopes for which a law might be restricted. A fundamental right can be restricted. For the public order, for health reasons, etc., rights of others. But then there must be this principle of proportionality, which was to a certain degree, we may say, developed by the German Constitutional Court. It has a very famous career all over the world. It has been picked up by the European Court of Human Rights, by the European Court of Justice. Even up to Australia now they're talking about proportionality, although they are more reluctant. What does it mean? It means that only means which are in principle legal, which are adequate, which are necessary, can be used. This is checked by the courts, and in the end there must be also a weighing between the scope you want to reach and the infringement you are imposing on the individual. When follow the scope. For example, let's take the case of pandemia. That the public health in general was the idea for the restriction, and on the other hand, were very strong restriction of personal freedom. If you cannot go out anymore, if you cannot meet your friend anymore, this is a very, very harsh restriction of your freedom, and there must be a weighing. And this is the principle of proportionality is very, very important. And here it is worthwhile studying the case law, not only of Germany, but of all other courts, the Spanish court, the European Court of Human Rights, the Portuguese courts, study the case law in order to get a feeling what it means, proportionality. And the last point I would like to mention, this is the judicial protection. There is no sense of having a nice enumeration of fundamental rights if there is not a real judicial protection. And we have this protection already by the fact that all courts are bound by the fundamental rights. They have to apply them in every case first, and then we have the Constitutional Court. And here there is a protection, and I would limit my explanation to one point. Every German person can bring a case before the Constitutional Court if he or she feels violated in one of the fundamental rights by whatever state action. Of course, after the exhaustion of all other remedies, but then the person can go before the court. This means against a law. This means against a treaty. There were the individual German citizens which stopped the...
Matthias, could you come to the end?
The integration process of the European Union. And you can go, of course, also against court decisions of ordinary courts in order to have them checked by the Constitutional Court. Therefore, this is very important for having an efficient protection, to have an organ, specifically, I would say, a Constitutional Court, which is able to protect the fundamental rights. Thank you very much.